We typically define a crime as a completed physical act, one person shattering a display case or carrying out a theft. In legal terms, this requires both the physical act, or actus reus, and the mental intent, the mens rea, to coincide perfectly. But the BNS 2023 expands this boundary. The code establishes that primary liability can exist even when the person coordinating the crime never touches a weapon or enters the scene. This is the realm of joint and constructive liability. In this module, we are examining how the law bridges the gap between those who plan and those who perform. This framework has 3 statutory pillars: abetment, conspiracy, and attempt. Abetment addresses those instigating or aiding another's actions. Conspiracy focuses on 2 or more people reaching an illegal agreement. Attempt triggers when a perpetrator takes direct action toward a crime, even if they fail. To understand exactly where these legal lines are drawn, we will work through a series of hypotheticals, sourced directly from the illustrations found in the Bare Act. These examples demonstrate that under the BNS, criminal liability attaches the moment intent manifests into a legally recognized action. Consider our first problem. Person A tries hiring person B for a murder, but B refuses. After that refusal, person A recruits a 6-year-old child to deliver a poisoned meal instead. The oblivious child completes the delivery. This creates 2 questions. Is A liable for trying to recruit B? And is A liable for using a child incapable of a crime? Section 45 provides the statutory foundation. A person abates when they instigate any person to do that thing, or intentionally aid the doing of that thing. Regarding B's refusal, look at explanation 2 of section 46. The code is explicit. It is not necessary that the act abetted should be committed. Because the instigation was finished the moment A made the request, A is guilty of abetment, regardless of B's agreement. Now we look at the child. Under section 20, an act by a child under 7 is not an offense. However, explanation 3 of section 46 prevents shielding the abettor. Illustration B confirms that instigating a child makes A subject to the same punishment. The law treats the child as an innocent proxy. A is liable as a principal. When a crime succeeds, section 49 states the abettor receives the identical punishment for that offense. If the crime does not happen, as with person B, section 56 provides a punishment of up to 1/4 of the longest term provided for that offense. This penalty increases significantly if the abettor or the person abetted is a public servant, whose duty was to prevent that specific crime. These rules establish abetment as a standalone offense. It punishes the act of promoting a crime, regardless of the participant's capacity or cooperation. But how far does this liability extend? What happens when a recruit deviates from the original plan? In problem 2A, an abettor instructs a proxy to poison target Z, but the proxy accidentally poisons target Y. Compare this to problem 2B.
An abettor instructs a proxy to commit arson. The proxy burns the house, but then independently decides to steal a television. The legal question is where the abettor's responsibility ends. This is determined by the probable consequence rule in section 51. The abettor is liable for the act done, provided that the act done was a probable consequence of the abetment. In the first case, a mistake in identity is a foreseeable risk of using poison. Therefore, the abettor is liable for the death of Y. But look at the arson example in section 51, illustration B. The theft is described as a distinct act and not a probable consequence of the burning. Consequently, the abettor is liable for the fire, but they are not guilty of the theft. This also applies to the severity of the outcome. If an abettor orders a physical assault, but the victim dies, we turn to section 53. Section 53 holds the abettor liable from the actual outcome, provided he knew that the act abetted was likely to cause that effect. If the abettor knew that ordering a severe beating would likely result in death, they are liable for murder. The BNS draws a boundary based on objective foreseeability. It holds participants accountable for logical results while protecting them from entirely unrelated criminal acts. Finally, we must now move from one person instructing another to scenarios involving collective planning and direct execution. In our third problem, 2 people agree to burglarize a house. One breaks in and uses a crowbar to pry open a jewelry box, only to find that it is completely empty. We must first determine at what point the agreement itself became a punishable conspiracy.
Section 61 defines a conspiracy, but its proviso specifies no agreement amounts to a criminal conspiracy unless some act besides the agreement is done. A mere verbal agreement isn't enough. One party must perform a distinct overt act, like purchasing the crowbar, to trigger the law. Next, we look at the attempt. Section 62 applies when someone does any act towards the commission of the offense. There is a clear progression here. Buying the tool satisfies the overt act of conspiracy, but applying that tool to the jewelry box constitutes the attempt. Even though the box was empty, the attempt is complete the moment the prying begins. The fact that the crime was physically impossible to complete because the jewelry was gone does not change the legal status of the attempt under Section 62. For this attempt, the perpetrator can be punished with up to 1/2 of the maximum term provided for the completed crime. This completes the triad of incomplete crimes. Abetment addresses the influence, conspiracy addresses the activated plan, attempt addresses the final execution. Sections 45 through 62 ensure that the law recognizes and penalizes the development of a crime. By holding planners and participants accountable for their specific roles, the BNS ensures the legal process of a crime is just as significant as its completion.